Number
You're welcome.
15, Alan Waddell. Thank you for being patient for the last people who were in the bucket. Thank you.
Front and center.
All right, so we have you here on a no valid operator's license. It looks like I'm still showing that it is expired. So what would you like to tell me today about the infraction?
Well, I'd like, Your Honor, if the court pleases, to certify the bond of subrogation, if you please.
Certify the bond of...
Yes, Your Honor.
Can you... Okay. One moment.
Yes.
So what would you like me to have certified?
The bond of subrogation.
What is the bond of subrogation?
You don't know?
Why don't you inform me? Is there a document that you have?
I can have the Justice Department send you one.
For what?
The bond of subrogation.
So, a subrogation agreement?
Subrogation is a bond.
Correct?
That's a bond that you place on my name.
I have not placed any bond on your name.
Well, this municipality most likely has.
You are Alan Lee Waddell?
Correct.
Okay. And so there's...
See, when this court is, if you hammer me, all that money in that bond goes to the IMF.
there is no bond. There's an infraction with a fine amount. So if that's what you want to tell me today, we're here for a contested hearing. I haven't heard anything that...
Latches and curs. Are you familiar with the Constitution? Latches and curs, right? I motion to dismiss.
Okay, motion to dismiss on what grounds?
On grounds that you do not know what you're doing. I'm sorry, Your Honor, you're supposed to know the law.
Okay.
Latches and curs.
All right. What legal authority do you have for your motion to dismiss beyond you don't think I know what I'm doing?
That will come from the Justice Department, Your Honor.
All right. Do you were stopped on February 25th, 2026?
According to Eric, the Kelso cop.
Okay.
Is he present? Is Eric present?
Did you subpoena him?
I did, and
did you file proof of service of the subpoena?
Excuse me?
Did you file proof of service of the subpoena?
I did. I filed a notice of liability.
That's not a proof of service.
It's a certified sign. It's a signed affidavit.
What signed affidavit do you?
It's supposed to be in your possession.
I have it.
Okay. Have you read it?
Yes.
It's notarized.
Okay.
It's a notarized affidavit.
Indiana Bill of Rights. None of this is binding on this court.
Those are case law, Supreme Court case law. Standing.
Indiana Article 1 Bill of Rights is not case law.
Well, we're applying it to.
We are not applying Indiana Bill of Rights to Washington.
Your name will appear here.
All right. Mr. Waddell, I have in front of me the officer's narrative indicating that he stopped you on February 25th, 2026, driving a maroon Chrysler PT Cruiser on the northbound 1400 block of South Pacific Avenue with its left and center brake light not functioning, initiated the traverse stop, identified himself verbally as Alan Waddell, stated he left his insurance back at his house and was unable to provide proof of insurance. The check of his DOL showed that it expired September 22nd, 2022. The photograph on Waddell's deal well. Record matched the driver, confirming his identity.
The defendant, Alan Waddell, relied on confusing and incorrect legal ideas like bond of subrogation, no contract, and references to the IMF. These arguments are commonly seen in pseudo-legal or sovereign citizen type defenses, which courts consistently reject because they have no basis in actual law. Instead of addressing the real issue, driving with an expired license, the defendant avoided the facts and failed to present valid legal arguments or evidence. As a result, the judge quickly dismissed his claims and ruled against him. This shows how misunderstanding the law can seriously harm a person's case.
And he issued the infraction. And you were warned about not having insurance and not having brake lights active. All right.
I informed the officer, Your Honor, at the time that there is no contract. The contract, the license, which is a contract, has expired almost 5 years ago.
Yet you were driving.
There is no contract.
You were driving on a public road. Okay. I'm going to find the infraction committed at the full amount of $564. You will have 60 days to either pay in full or set up a payment plan.
I will this, and
What was that?
I will have to recommend it. I must recuse you, Your
Okay,
Honor.
you can file that with the, you
At this
can
point,
make a
yeah.
motion, but I've made my ruling at this point.
I'm motioning for a mistrial, and I'm going to recuse you.
Okay, I'm
from this
denying
case.
those motions as they are not timely nor relevant at this point.
Under the
So your infraction
Constitution-
has been committed. If you would like to file motions to
You are
appeal
in direct
this,
violation
go
of the
ahead.
constitutional rights, Your Honor.
All right,
You
Mr.
are
Waddell, that'll
committing-
be all for today. All right, number 16, Robert Warren.
Yeah, guys, he was just sitting on that other date.
Okay.
All right. We'll see you back here on the 29th of May, sir.
Thank you.
Prince Pugh, would you please start a record?
Yes, Your Honor, thank you. This is State of Indiana versus Prince Pugh. The cause number is 64D012305, ISO F54448. Defendant is present in court in person by video conferencing, is here with counsel, Mr. Steve Provost, State of Indiana by Gary German.
I think it's an F6, though. That's just a typo. It's definitely 2305 F64448. Morning, Mr. Pugh. Can you hear us okay?
Yes.
Okay, thank you. Mr. Provost?
Your Honor, I don't have anything new to report to the court. I haven't been able to see Mr. Pugh since he was rearrested on this matter. However, I have reviewed the pleadings that Mr. Pugh has filed, and I guess I'm looking to get some clarification from the court and Mr. Pugh as to my office's involvement in this matter, Your Honor. From what I've read, it appears Mr. Pugh is desirous of representing himself in this matter and has filed his own pleadings in accordance with that desire. But I want to be clear if in fact that is what he wants and if my office should be withdrawing from this case.
Well, what happened was I entered an order striking some pleadings back in November. There were some more pleadings that were filed. I struck those in last week. And then there were some more pleadings filed, and I have a motion, or an order rather, that strikes those. But while it was in the work queue, some more motions came in. So I needed to work on the order to strike the additional pleadings that came in. We don't allow for hybrid representation in this court, Mr. Pugh. So I've appointed counsel for you, and you need to file anything that would come to the court has to come through counsel. You can't file things on your own, sir. You understand that?
No, I do not understand that.
Okay, well, that's how it is. So anything you need to file has to come from your lawyer. And if it doesn't come from your lawyer, I will strike it from the record because we don't allow what we call hybrid representation. Okay?
I object.
Okay, we'll note your objection for the record, sir.
Your Honor, do we need to have any discussion with Mr. Pugh on whether he wants to proceed pro se?
I don't have a motion from him to proceed on his own and without counsel.
May I ask, I understand you're not going to address it today, Your Honor, but just so I'm clear.
I mean, he hasn't filed that motion.
Yes, I filed a motion for a special appearance.
Yeah, that's meaningless to me, sir. And I struck that from the record, so it's of no moment.
Indeed, I object.
Noted. So I'm just going to set you over, Mr. Purple. Is that what you need?
Yes,
Some more time?
Yes.
My Honor, are you aware that the respondent is a national citizen to the United States of America Republic, which is a sovereign government that has its own jurisdiction? Is the court aware of that?
Mr. Pugh, I'm going to set your case over for a few weeks to June the 12th at 8:30. I'll have you back June the 12th at 8:30, and we'll see you back here then.
I object.
Noted.
The judge followed proper legal procedure, asking for clarification, checking evidence, officer's report, and giving the defendant a chance to respond. In contrast, the defendant interrupted, made unsupported motions, like mistrial and recusal, and failed to follow procedural rules such as properly subpoenaing the officer. Courts rely heavily on structure and timing, and the defendant's lack of procedural knowledge weakened his position. The outcome highlights that respecting court process and presenting relevant arguments is just as important as the facts themselves.